Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law. Please subscribe to our channel. Well, when you file divorce cases and custody cases, eventually you know what you're going to get? Court dates. What do you do if you have an upcoming court date? Well, it's very important that you and your attorney should have a certain coordination of activities with respect to the court date. If we've got something coming up, for example, it might be appropriate that you and your attorney have a discussion in the way of a prep session so that you should know what's going to go on. Not all court dates are the same. Some court dates are more in the nature of settlement conferences where your personal participation will likely be nominal. The same is true with status conferences and those kind of things where the attorneys tend to play more of a role. I would certainly say of those two items that I just delineated, your role will be smaller in the status conference. You might have a more significant role in a settlement conference, but the point is that there are different kinds of court proceedings. Of course, if there's a court proceeding that involves testimony, like an evidentiary hearing, that's a proceeding where you can well expect that your involvement is going to be significant. So in a hearing like that, where you're going to be examined and possibly cross-examined, likely under oath, and you're going to have to give statements that may or may not determine, how assets are divided or how custody is decided. If that's the case, it's probably appropriate that you should have some idea of what you're supposed to do, what you're supposed to say, and what's going to go on. You have to remember that your demeanor outside the courtroom should be significantly different than what goes on for the record inside the courtroom. You can be, there can be certain conduct that is totally acceptable in a social setting, which it would not be acceptable in a courtroom setting. You have to remember that everything counts. The way you present yourself, the things that you say, even certain movements that you might think aren't really relevant. The court may be looking at that, a roll of the eyes or some sort of frustrated gesture. That could count against you. So you have to be very, very careful about things that you do and say. For example, a lot of times people, I've seen this many times, they'll be giving testimony and they'll stop and they'll just say, Can I just say something? The answer is no. You cannot just say something, because when your lawyer asks you a question, for example, he might ask, what year did you get married? The number that what he expects to come out of your house is a number. It's going to be in 2000 and something, more likely than not, or even 1900 something. But that's what he expects. That's what he can control. The moment you start on your own with the "can I just say something," you're about to get into a story that he doesn't want, didn't ask for, and the court probably doesn't want to hear. Remember one other thing. Lawyers are professional question askers, okay? If they want to know something, they're going to ask you, and then you'll be able to come out with it, and it'll be orderly, and it'll make sense, and that's how you should proceed. And amongst the best things that your lawyer can prep you for is not so much what the facts are, because you probably know what your wife is like, what your husband is like, what your kids are like. You probably know that without much prep. What you need to be disciplined on is to answer the question that you are asked. Now, this is something that a lot of people have trouble with. So when you want to know, you got an upcoming court date, what do you need to know about that? What do you need to do? Well, you need to prepare to be in the environment where you're answering questions appropriately so that it'll help your position. If you have any questions about that, reach out, and we'll be glad to help you out.